the appearance
I
of the
understand
injury.
that.
And
My
I think
question is just very specific. You can't determine the object that caused the injury to Mr. Depp's finger.
Welcome to Jailhouse Law. Today we're going into Amber Heard's experts getting absolutely eviscerated. In fact, I've got several portions of testimony from them, and I had to separate it because it's just so much. But right now we're going to deal with the expert that got on the stand, and he started testifying as to whether or not Johnny Depp actually suffered the injury that he said, with his finger. And the testimony, the crux of this guy's testimony was that, it couldn't have happened how Johnny said it happened. And so basically to undermine Johnny's allegations that Amber Heard, severed his finger with the vodka bottle. His analysis centers on because his hand couldn't have been sitting there and that injury had happened, the injury would have looked differently had everything happened exactly as he said it happened. How they even thought this testimony would actually fly or go over, I don't know. It kind of reeks of desperation. But let's take a look at some of the things he had to say.
the appearance
I
of the
understand
injury.
that.
And
My
I think
question is just very specific. You can't determine the object that caused the injury to Mr. Depp's finger.
it's a little bit more of a non-specific answer. I mean, I can't determine the exact object, but I can determine that it's unlikely that it was sustained in the manner described.
A bottle is a foreign object, isn't it?
Yes.
Okay. So you can't rule out that the injury to Mr. Depp's finger was caused by a vodka bottle, correct?
Well, based on the injury pattern, I can say that the described mechanism of injury is inconsistent with medical findings.
Right. But because a vodka bottle is a foreign object, you can't rule out that a vodka bottle is what caused Mr. Depp's injury.
Well, I can't rule out that a vodka bottle caused the injury, but I can rule out that it was caused in the manner described in his testimony.
And that's the thing that was really getting on my nerves. She would ask him a question, and instead of answering the question, he still wants to get to a point. This is the problem with that. He's supposed to be an expert. And I've noticed that with regards to these experts, that they seem to be very invested in a side. And that's not what you're supposed to be there as an expert. If you're an expert, you're supposed to be there to provide your expertise. That's it. Now, if somebody's questioning your expertise, then you may feel some type of way about it. But as it relates to the ultimate facts of the case, just provide your testimony. That's it. That's your job. Your job is to provide your testimony, your expertise. And so when she's asking you, you can't state that it wasn't caused by a vodka bottle. Yes, correct. I cannot state that it was not caused by a vodka bottle. That's it. The fact that he feels the need to then add, I'm just saying that it could be, but that it's inconsistent with the method that he described. She didn't ask you that. And it's not your job. It's not your job to worry about that being relayed to that information being relayed to the jury. It's not your job to make sure, make sure they know this. That right there reeks of the partisan nature and the lack of objectivity of these so-called experts. Because your job should be just to answer the questions, factually give all the information out. And I think it even comes up later on with the judge has to say, you'll be able to redirect. That's the function. If one side doesn't like what information is coming out from their expert, they get a chance to ask the questions to get to the information that they want to be highlighted, to get to the information that works in accordance with their conclusions. They get a chance to ask the questions that will highlight, this is what we've said it is, A, B, C. But if there's anything that can undermine it, that's the job of the other side to say, hey, this shows you're not saying it can't be ruled out. You're not saying that a vodka bottle didn't do this. You're not saying that. The answer is right. I'm not saying that. That's it. It's not his job to then go back and say, no, but it's just that it couldn't have happened the way he said. Nobody asked you that. Nobody asked you that. When the other attorney, when the defense attorney asks you that, then you can answer that question. Nobody's asking you that question now. Stick to the questions.
You can't rule out that the injury was caused by a knife, right?
I think it's unlikely that the injury was caused by a knife.
But you can't rule it out.
Well, if a simple knife laceration wouldn't impart the injury to the distal phalanx to result in the comedy fracture. Now, a chopping type, but again, that would likely come from a direction that would create a dorsal injury to create the fracture that was developed.
Do you remember giving testimony in this case, Dr. Moore?
Deposition?
Yes.
Yes,
Okay. And you were under oath, correct?
correct.
All right. And that was on March 22nd, 2022. Yes?
Correct.
Okay.
And this is the thing that's really interesting about this testimony in the first place. And like I said, I don't even know why this dude has been called as an expert, because a lot of times this probability, this what if, there's too much weight given to some of these experts. And if you look at the history of something like fingerprinting, like there's these fields where people are basically guessing. They're guessing, but they're sitting up on the stand and saying, well, in my professional opinion. And when you listen to them, it's like, well, your professional opinion sounds like it kind of sucks in terms of, it doesn't even sound like something that you could quantify to being able to know that it couldn't have happened or that it could have happened. Do you know what I'm saying? And like there's way too much weight being given to this testimony, but the way she breaks it down is just really, really amazing, because she's just getting started.
Line 4.
Correct.
Question, but you can't rule it out completely, right? Answer, I can't rule anything out completely. I can't rule out that he caught it in the door, cut it with a knife, or slammed it in the car door. Or, again, as Dr. Gilmer said, we can't definitively say what caused this injury. Did I read that correctly?
You did.
Your Honor, I would object as to the incomplete impeachment. I think if she's going to read his answer, she also needs to read or give Dr. Moore the chance to read the paragraph below. She just picked out half of his answer.
You can redirect.
Yeah,
I'll
as
rule the
well as the
objection.
paragraph above.
Dr. Moore, there's no question pending. Thank you, though.
And this is what I was talking about. I was talking about how, one, the other attorney tries to chime in. Oh, well, you should be looking at this, judge. And the judge is she shouldn't be allowed to just read that portion. She should have to read the whole thing. Like, no, this is her portion of the case. She gets to ask what she wants. She gets to focus on what she wants. You're a lawyer. You're an attorney. You should know this. The judge has to step in and say, you have the opportunity to redirect. If you think this looks skewed, if you think this makes your expert look bad, you have the opportunity to ask him questions to make him look good again. You have the opportunity. Whether or not you have the ability, that's a completely different matter. But you have the opportunity to rehabilitate your witness. You have the ability to rehabilitate your witness. And then she really goes in. She really goes, because this is the point that's key. Because like I said, there's a lot of extra stuff coming from these experts. A lot of extra stuff, and this behavior is not of disinterested, objective third parties. These seem to be people who have an agenda, who are like, oh no, not only do I have to say it, I gotta get my point out, and she has to shut them down. Like, no, you're not being asked a question. Stop talking. Like, it's not your moment to just go on soliloquies and explain everything for, no. You prepare a report. The lawyers prepare a case. Your job is to prepare a report. The lawyer's job is to prepare the case. But she had to shut him down. Camille shut him all the way down. No, stop talking. I ask you questions. You answer my questions. This is not you talking to them. This is you answering me. You don't have it's not your job to focus on, oh, I want the jury to understand this. Nobody gives a damn what you want. Your job is to provide the testimony to provide your expertise as it relates to this issue. Their job is to try to make sure the jury sees their side of the case. If that's your job, that severely undermines any confidence in your ability. And that's why I looked it briefly up. Virginia has its own rules of expert testimony. But the federal courts have this thing called the Daubert standard. And I'm not saying the Daubert standard is always used. I know when I challenged testimony based on it, that testimony, and this is my opinion, was not properly admitted, because there was a clear evidence of bias. There was a clear evidence of bias, clear evidence that the expert, regardless of what expertise they may have had, that expertise was not being used. They were not providing professional opinion and maintaining the standards of their field to provide that testimony. So yeah, that's why I really enjoyed seeing, those lawyers put in that work on these experts, because I've dealt with experts that aren't disinterested parties, like experts with an agenda. That's an issue.
So you can't rule out that the injury was caused by a car door either. Is that right?
Correct.
Okay. But it's your testimony sitting here today that you can rule out that the injury was caused by a vodka bottle. Is that your testimony?
My testimony is that I can rule out the injury as caused by the mechanism described by Mr. Depp in his deposition.
But you can't definitively say what caused the injury to Mr. Depp's finger.
Well, the definitive injury is a crush injury, again, I can't say. I mean, I think that it's quite likely that the initial mechanism described at the time of presentation of the accordion doors would classically create this injury pattern. The hand up in front. If you picture accordion doors as the edge is closed, if the hand's up, the palm is exposed. If the door's pushed, and the
Dr.
hinge
Moore,
closes about the fingers.
I understand that. But my question is,
I think it's important that they understand that.
this is the time for me to ask you questions. Your counsel will have the ability to rehabilitate you and ask you questions on redirect. Right now, let's try my question.
Okay.
You can't definitively say what caused the injury to Mr. Depp's fingers. Yes or no?
No.
Okay. In conducting your analysis of Mr. Depp's finger injury, you did not attempt to reconstruct the incident. Is that right?
Well, I think the incident was reconstructed. You mean did I throw a vodka bottle at something?
No, no, Dr. Moore. I mean, you didn't do any type of accident reconstruction, either computerized or you didn't conduct any type of accident reconstruction of the alleged.
No, that's correct. My opinion is based on the medical records and the clinical images and Mr. Depp's description.
And your analysis is based on an understanding of how Mr. Depp described the exact position of his finger at the time of the injury, yes?
Yes.
Okay. And your analysis is also based on the assumption that Mr. Depp's hand remained completely still in the instance that a vodka bottle was hurled at him, yes?
No, my assessment is on his description of the vodka bottle striking the top of his finger.
But his hand stayed still, according to your analysis, yes?
I guess it was still long enough for the bottle to hit it, but natural reaction would be to try to pull away.
And that's where she hits it on the head. That's where she hits it on the head. Answer my questions. Oh, well, I need to explain. No, you don't need to explain anything to the jury. Answer my questions. If there's something that defense counsel thinks needs to be understood by the jury, they can ask you those questions. If they think there's something the jury needs to know, they can ask those questions. It's not your job. But that's the theme of a lot of these experts. A lot of these experts seem to be having something to prove, having a specific agenda they're pushing forward. That's something I think that severely undermines their believability and their reliance as expert witnesses. When she says that question, when she asks that question about his hand remaining still, I'm like, of course, yes. Because something that's so simple that accounts for your entire theory that, oh, well, it couldn't have happened like he said because the injury doesn't look like it would happen if his hand was just, well, his hand isn't still going to be sitting there. And if there's something happening and his hand was initially in this position, because you can't rely on him to be able to tell you while a bottle's flying at his finger what exactly his hand was doing. Like that's unreasonable. So to understand that he can give you an approximation of how his hand was prior to, he doesn't actually, like, boom, he gets injured. His hand clearly is going to move. His hand clearly is going to move. Now you have some kind of reason why it might not be from the top of the finger, why you may not be seeing the marking and the damage from the top of the finger that you're expecting to see if his hand is stationary, like right here. Because his hand's not going to stay stationary. Of course his hand's not going to stay stationary. It wouldn't make any sense for his hand to stay stationary. Love that she hit that home.
Thank
There we
you.
go. Okay.
Have you ever seen this picture before, Dr. Moore?
No,
So you're not aware that this is the bar area where Mr. King testified he found Mr. Depp's finger?
no,
Do you see that broken vodka bottle in the back corner near the bottom of the bar?
yes,
Do you see the blood drops on the floor?
yes,
Can we please pull up Defendant's Exhibit 1820, which is already in evidence? Have you seen this picture before, Dr. Moore?
I have not.
So you're not aware that this is also a picture from the bar area where Mr. King testified he found Mr. Depp's finger?
Correct.
And that's how you do it. Let's deal with actual evidence. Let me provide you the actual evidence that this happened. Let me provide you the actual evidence. And it's interesting because he even tried to say, oh yeah, well, it makes sense if it happened in the accordion door. Okay, well, guess where the finger was found? Guess where there's a broken vodka bottle on the floor. There's blood, there's drops of blood on the floor. They find the finger by the bar. This is what the evidence actually shows. This is what the evidence actually shows. Not this, and I'm not saying his entire field is pseudoscience, but the way he presented it, and with such an agenda, he undermined his expertise. So his testimony comes off as pseudoscience. His field may be actual science. His testimony comes off as blatant pseudoscience, and his interest, his explicit interest in wanting to portray a certain picture, to tell a certain story. No, just the facts. Stick to the facts. But his inability to do that, and the fact that she had to just end it with actual evidence. And that was just one of the eviscerations of experts that happened on Monday. Just one of them. As always, thank you for checking out this episode. Don't forget to hit that thumbs up, like, share, subscribe if you haven't subscribed already. And thanks for checking out Jailhouse Law, because sometimes you got to do it yourself.